Hello and welcome. I will be reading the full document of what was recently filed from the Karen Reed defense team on September 24th, 2024. Today is September 26th. So this is the full document, and as always, I will leave the link in the description below if you would like to read it yourself without my commentary. It reads, Commonwealth of Massachusetts Supreme Judicial Court, Suffolk County, Commonwealth Appellee versus Karen Reed, Defendant Appellant. On appeal from reservation and report of GLC 211 subsection 3, petition, brief of appellant Karen Reed. So this is the brief that Karen Reed's defense team submitted just 2 days ago. And it lists her attorneys again, Martin Weinberg, Michael Pabian, Alan J. Jackson, and David R. Yannetti. It's dated September 24, 2024. And it is a long document. It's over 70 pages long. I'm aware that the first 20 pages are more of the backstory that we sort of all know about. Table of authorities. So I will try to get through the first 20 pages quickly without much commentary. All right. And it reads, Statement of Issues Presented. 1. Whether the jury's final unanimous agreement following trial that Miss Reed is not guilty of counts 1 and 3 constitutes an acquittal for double jeopardy purposes and precludes retrial on those counts. 2. Whether Miss Reed was alternatively entitled to a post-trial inquiry to substantiate her claim that the jury acquitted her of counts 1 and 3. 3. Whether there was manifest necessity to support the declaration of a mistrial on counts 1 and 3, where 1. The jury was not deadlocked and in fact had reached a unanimous agreement on those counts. 2. The trial court provided no opportunity for Miss Reed or her counsel to be heard regarding the declaration of mistrial. And 3. The record reflects no consideration of alternatives to a mistrial when in fact such alternatives existed and were codified in Mass. R. Crim. P. 27B, Massachusetts Rules of Criminal Procedure, Rule 27B. So it starts off listing their main arguments, their main issues. And according to this, they have 3 official arguments that they are wanting the appellate court, the Supreme Court, to decide on. And to me, they are all valid arguments. I am hoping that at the very least, the Supreme Court, the appellate court, grants them number 2, at the very least. I mean, even if they don't agree, if they're going to coincide with Judge Bev, and say, well, it wasn't announced in open court, so therefore there are no verdicts. Then at the very least, in my opinion, especially because Judge Beverly Canone herself said that what the jury members said was true and accurate. Judge Bev herself acknowledged that Karen Reed was found not guilty of counts 1 and 3. Judge Beverly Canone considers that true and accurate. So in my opinion, the appellate court should at the very least grant the defense team number 2, that the jury should be spoken to. They post-trial, they should be given the opportunity to be heard by the court. And to me, it should be a completely different judge at this point. At this point, it should be an entirely different judge who listens to them as they tell that judge and the court that Karen Reed was found not guilty on counts 1 and 3. And again, I don't see anything unreasonable about requesting that. Again, especially when a judge herself acknowledges it as true and accurate. I was going to say something else, but the train of thought just escaped me. All right, continuing to read the document. Statement of case. On June 9th, 2022, Miss Reed was charged in 3 separate indictments with second-degree murder in violation of 365 subsection manslaughter. We know the counts by now. I'll just try to skip through those counts. All right. The trial court declared a mistrial on July 1st, 2024. Miss Reed moved to dismiss counts 1 and 3 on double jeopardy grounds, contending 1, that the jury reached a final unanimous decision to acquit her on those charges, and 2, that there was no manifest necessity supporting the mistrial given the evidence that the jury was not deadlocked, but was instead in agreement on those counts. As set forth in more detail, the motion was predicated upon affidavits by counsel reflecting statements of 5 deliberating jurors that the jury had agreed Miss Reed is not guilty of the relevant counts. It continues, after hearing oral argument on August 9th, 2024, on August 23rd, the trial court issued an order denying Miss Reed's motion to dismiss. The court accepted for the purposes of the motion to dismiss that the juror statements quoted in the defense affidavits were, quote, true and accurate. Yes, they were. Yes, that's what happened. So let's hope the Supreme Court, at the very least, pushes forward with that fact. Continuing to read. Order at 9 R396, it's citing it. Emphasis added. It went on to hold, however, that, quote, because there was no open and public verdict affirmed in open court rendered in this case, the defendant was not acquitted of any of the charges, end quote, because that's exactly what Judge Bev wanted. It continues. The court similarly rejected the defense argument regarding lack of manifest necessity, finding that A, Miss Reed's counsel consented to a mistrial via their failure to object, and B, the jury notes reflecting an impasse established the requisite manifest necessity. Finally, the court rejected the defense's alternative request for a post-trial inquiry on the grounds that Miss Reed's argument did, quote, not implicate racial bias on or her right to receive an impartial trial, end quote, and because it believed that the request implicated, quote, the substance of the jury's deliberations, end quote. Miss Reed's retrial is currently scheduled for January 27, 2025. On September 11th, 2024, Miss Reed filed a petition for relief pursuant to GLC 211 subsection 3. On September 19th, 2024, the single justice Juror reserved and reported the case without decision to the full court. So it's just a backstory. All right. Statement of facts. On June 25th, 2024, the jury began deliberations after receiving instructions from the trial court. The court instructed the jurors, quote, you should continue deliberating until you have reached a final verdict on each charge, end quote. June 25th, 2024. It also noted that count 2 contained, quote, lesser included charges, end quote, of involuntary manslaughter and motor vehicle homicide, which the jury should consider, quote, even if the Commonwealth failed to provide the greater charge of manslaughter while operating a motor vehicle under the influence of liquor, end quote. The following day, on June 26, 2024, outside the presence of the jury, counsel for Miss Reed raised an issue regarding the verdict form, With respect to count 2, the original verdict slip provided only one option to find Miss Reed not guilty before going on to ask whether Miss Reed was guilty of the offense charged or guilty of one of the two lesser included offenses. See Exhibit B. So, continuing, counsel asked that the form be amended to provide, quote, not guilty options for the subordinate charges under count 2, end quote. June 26, 2024, the trial court initially indicated its disagreement with counsel's request. However, after considering the matter further, the court agreed to provide supplemental instruction and an amended verdict slip. Later that day, the court provided the supplemental instructions, telling jurors that, quote, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a vehicle under the influence of liquor, end quote. And pulling away from this, as I have said before, count 2 was purposefully written that way. Count 2 was a trap. And the state knew it, the prosecution knew it, Judge Bev herself knew it. They knew that they could get Karen Reed on the BAC level, on the alcohol level, which again, I dispute the credibility of. If everything else the state and the prosecution brought forward was a lie, it was manipulated, it was falsified, then I do not trust the alcohol level they allege that Karen Reed had. I also don't consider it because, again, no one else's alcohol level was tested that night, and everyone, including members of law enforcement, everyone was drinking and driving that night. So, to me, Karen Reed's alcohol level should have been thrown out, but unfortunately it wasn't, and that's why count 2 confused the hell out of the jury. All right, continuing to read. The jury should first focus on that, quote, lead charge and, end quote, and, quote, if the Commonwealth failed to prove that crime beyond a reasonable doubt, then consider the remaining lesser included offenses in descending order, end quote. On June 28, 2024, the jury sent the following note to the court, quote, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict, end quote, June 28, 2024. The court added counsel for their views, quote, on whether there had been due and thorough deliberations, end quote, sufficient to support the giving of a so-called Tui Rodriguez charge. It's just citing their attached documents. All right, and continuing, the Commonwealth responded that the charge should not be given because there, quote, simply hadn't been sufficient time yet, end quote, June 28, 2024. Counsel for Miss Reed disagreed, requesting that the court, quote, read the Tui Rodriguez model instruction and go from there, end quote. The trial court sided with the Commonwealth, ruling, quote, I am not prepared to find that there have been due and thorough deliberations at this point, so I am going to send them back out, end quote. On July 1st, 2024, the jury presented another note stating, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. July 1st, 2024. Upon being asked by the court, the parties reiterated their same previously expressed views, with the Commonwealth taking the position that due and thorough deliberations had not yet occurred, and Miss Reed's counsel arguing that the court should give a Tui Rodriguez instruction. This time, the trial court decided to give the requested instruction. Later that day, the jury sent yet another note. Thereafter, without reading the note to counsel and without providing counsel with either an opportunity to be heard or an opportunity to consult with their client about the implication of a potential mistrial on one or more charges, the trial court simply stated, quote, "The jury is at an impasse," end quote, and called in the jurors. It then read the note on the record. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. After reading the note and without soliciting the views of counsel in any respect, the trial court stated, quote, "I am not going to do that to you folks. Your service is complete. I am declaring a mistrial in this case," end quote. The jury was then excused and ordered to leave the courtroom. Counsel was not invited to speak during this entire interaction. The following day, on July 2nd, 2024, unsolicited by any party, one of the jurors, Juror A, contacted one of the attorneys for Miss Reed, Alan Jackson. Juror A stated that he or she, quote, wished to inform Attorney Jackson of the true results, end quote, of the jury's deliberations. Affidavit of Alan J. Jackson. According to Juror A, quote, "The jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime," end quote. Quote, "The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury death. That's how it's written. One day later, on July 3rd, 2024, another attorney for Miss Reed, David Yannetti, was contacted by, quote, 2 different individuals hereinafter, Informant B and Informant C, who had received information from 2 distinct jurors hereinafter, Juror B and Juror C, both of whom were part of the deliberating jury in this case," end quote. And it provides the affidavit. Informant B sent Attorney Yannetti, quote, "a screenshot she had received from someone hereinafter, Intermediary B, of text messages that Intermediary B had received from Juror B. In that screenshot, Juror B texted the following to Intermediary B, quote, "It was not guilty or second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose," end quote. Juror B later placed an unsolicited phone call to Attorney Yannetti, confirming that the information contained in the publicly filed affidavit was accurate. See supplemental affidavit. Quote, Juror B clarified, however, that she meant to write, "No one thought she hit him on purpose or even knew that she had hit him," end quote. Juror B further told Attorney Yannetti she believed that every member of the jury if asked, would confirm that the jury reached not guilty verdicts on indictments 1 and 3, end quote. Informant C had been in contact with another individual, intermediary C, who is a coworker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent Attorney Anetti the below screenshots of her text messages with intermediary C regarding what Juror C revealed in the Zoom meeting, and provides the statements we read previously. No consideration for murder 2. Manslaughter started polling at 66 and ended deadlock at 4 no, 8 yes. Interesting, if it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip. That was all confusing. She should have been acquitted. I agree. Yes, the remaining charges were what they were. Hung on, and that instruction paper was very confusing. Affidavit. In the ensuing days after the filing of Miss Reed's initial motion to dismiss, but before the Superior Court hearing on that motion, Attorney Jackson was contacted by 2 other deliberating jurors. The first, Juror D, stated, quote, that the jury reached not guilty verdicts on count 1 and 3, and that the disagreement was solely as to count 2 and its lesser offenses, end quote. Supplemental affidavit of Alan J. Jackson. He recounted that, quote, after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and 3, end quote. Juror D unequivocally told counsel, quote, every one of us will agree and acknowledge that we found Karen Reed not guilty of count 1 and 3, because that's what happened, end quote. Juror E similarly stated, quote, that the jury was unanimous on 1 and 3, that Karen Reed was not guilty of those charges, end quote. Second supplemental affidavit. The Commonwealth filed a post-trial notice of disclosure informing the court that, quote, on Sunday, July 21st, 2024, Assistant District Attorney Adam Lally received an unsolicited voicemail on his office's phone line from an individual who identified theirself as a juror by full name and seat number, end quote. Commonwealth notice at 1... it's citing the attachment. The message stated, quote, it is true what has come out recently about the jury being unanimous on charges 1 and 3, end quote. ADA Lally received a subsequent message from the same individual stating he could, quote, confirm unanimous on charges 1 and 3 as not guilty, and as of last vote, 9-3 guilty on the manslaughter charges, end quote. The Commonwealth additionally, quote, received emails from 3 individuals who identified themselves as jurors, end quote, and indicated they wished to speak anonymously, end quote. The Commonwealth declined to substantively respond to the voice messages or emails, instead claiming in responsive emails that it was ethically prohibited from discussing such matters. Yep, we all remember that. Yep, so ethical. They're so ethical. So worried about being ethical. Yep. It continues. Summary of argument. The very day after the trial, court declared a mistrial. Counsel for Miss Reed began receiving unsolicited communications from 5 of the 12 deliberating jurors, in 4 instances directly from the jurors themselves, indicating unequivocally and unconditionally that the jury had a firm and unwavering 12-0 agreement that Miss Reed is not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. Crucially, neither the Commonwealth, which frankly acknowledged receiving communications from 1 juror to the same effect, nor the Superior Court judge, who expressly accepted the veracity of juror statements relayed in affidavits by counsel, disputed the factual basis for the defense motion in any meaningful respect. So pulling away here, what Karen Reed's lawyers, what her defense team is saying right here in the sentence, is that neither the prosecution nor Judge Bev disputed the facts, the factual basis for the defense's motion to dismiss in any meaningful respect. So they're saying that neither the prosecution nor Judge Bev, in their responses to the motion to dismiss, neither of them actually argued it in any meaningful way. They provided non-arguments, and I wholeheartedly, 1000%, agree with the Karen Reed defense team here. As I have commented, I commented on the prosecution's filing, Norfolk County DA's office filing, and I commented on Judge Beverly's filing herself, on what she filed herself. And both of their filings provided case laws that, to me, were not applicable. And both of them swore, like their main argument was about the form, about following the procedure, when in fact, Adam Lally himself failed to follow multiple procedures. Adam Lally himself changed his narrative about what happened, even from his opening statements to his closing statements. I made a video about this, that in his opening statements, he had one argument for John O'Keefe's wounds, and in his closing arguments, Adam Lally had a completely different argument for John O'Keefe's wounds. And then Judge Bev herself, when she declared a mistrial, she did not follow any rules. She did not give either side, either the prosecution or the defense, an opportunity to speak. And when before, with all the notes previous to the mistrial, she allowed both sides to speak. But when she declared a mistrial, she did it swiftly. She did it swiftly, abruptly. She did not allow either of them to speak. And again, the Judge Bev was able to communicate with the foreperson privately. So I'm just saying there was a lot there going on that Judge Bev was fully in control of, and she was not following the rule. And yet she and the prosecution swore that the defense didn't follow any rules. And it was hypocritical, and it was a non-argument because, again, there were safeguards there that Judge Bev was supposed to follow, and she did not. And not even the prosecution held Judge Bev accountable, which again leads me to believe that they were in cahoots. They were in cahoots together. All right, continuing to read. Despite the widespread media given to the defense filings of the attorney affidavits attesting to the jurors' representation, they had acquitted Miss Reed of 2 of 3 charges. No juror disputed the facts represented by the attorneys in any manner. It's true, pulling away, it's true that the jurors who came forward to the defense and to the prosecution, they all had the same thing to say. And since those jurors came forward, no other jurors came forward to dispute what those jurors had said. And again, Judge Bev Canone herself, considered those jurors' statements true and accurate anyway. So, again, it's like none of the jurors are disputing that count 1 and 3 had 12-0 verdicts, that Karen Reed was not guilty. Continuing to read, given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. This presents an issue of first impression for this court, as does the defense's alternative contention that Miss Reed was entitled to a post-verdict inquiry to substantiate her claim, and that this court's precedents permitting such inquiry regarding claims of external influence and or juror bias should be extended to the present context. Independently, while the jury deadlock constitutes manifest necessity to support a mistrial, there is no authority for the proposition that disagreement as to some counts constitutes manifest necessity for the declaration of a mistrial with respect to all counts. Put another way, there was no deadlock as to two of the counts on which the trial court declared a mistrial. The trial court's finding that Miss Reed's counsel consented to the mistrial is contrary to both the factual record and the clear binding case law. The trial court, in its opinion, erroneously failed to apply clear state and federal case law that places the burden of establishing manifest necessity solely and exclusively on the prosecution rather than on the defendant. The trial court also failed to address the two guiding principles set forth by this court in Commonwealth v. Stewart and Commonwealth v. Taylor, that before a mistrial is declared, quote, counsel must have been given full opportunity to be heard, and two, the trial judge must have given careful consideration to alternatives to a mistrial, end quote. The court instead erroneously equated a request for a Tui Rodriguez instruction, which is designed to encourage a verdict, with consent to a mistrial. In sum, whether the jury acquitted Miss Reed or alternatively was merely not deadlocked on the relevant counts, the Constitution requires the same result, dismissal. Argument. The ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people, Erlanger versus United States. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions, end quote. Quote, prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them in many cases of the benefits of trial by jury, end quote. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty, end quote. And pulling away, for those who are feeling like this is sounding familiar, it is because these are the identical arguments they provided in their motion for relief. So they essentially are providing the same arguments in their argument here in this filing as they provided with their motion. So it might seem redundant, but they're doing it because it's their case. It is their motion for relief, and everything is cohesive between the motion for relief and these written arguments, which the Supreme Court had required them to submit. They had a deadline to submit it. All right, continuing to read. Again, I will leave the link in the description below if you want to read it yourself. It continues, it follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. See Taylor. Quote, perhaps the most fundamental role in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution, end quote. Quote, the double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb, end quote. Quote, the underlying idea, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense, end quote. Quote, even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which he or she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. Consequently, as a general rule, the prosecutor is entitled to one, and only one, opportunity to require an accused to stand trial, end quote. And I read this other quote from this case law. Quote, at the heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression, end quote. Quote, the clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty, end quote. The court, quote, reviews determinations regarding double jeopardy de novo, end quote. And 1, Roman numeral, the jury's unanimous conclusion following trial that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. Quote, what constitutes an acquittal is not to be controlled by the form, end quote, of the action in question. It provides the case law, quote, rather, the court must determine whether, end quote, the action, quote, actually represents a resolution, correct or not, of some or all of the factual elements of the offense changed, end quote. Just pulling away, I just want to say that the defense is stressing that great care is supposed to be taken when you're putting someone in a position like Karen Reed, when you're dealing with the trial process, with the court process. Great care must be taken for the accused. You must be diligent. You must be thorough. You must make sure you are following the rules that have been in place for a reason. You must make sure that you're not re-prosecuting someone unnecessarily. And remember, this is the U.S., this is the United States. And in the United States, you are supposed to be innocent until you are proven guilty. These are all standards, right? And this is what the defense is arguing, that the court should not be so fixated on what the literal definition of a verdict is, according to Judge Bev, that a verdict is only a verdict if it's announced in open court. Especially when we don't even know why the jury didn't tell the court that Karen Reed was found not guilty on count 1 and 3. But we do know that the jury were confused post-trial. We do know that the jury found her not guilty of counts 1 and 3 post-trial. So regardless of what was or was not announced in open court on that day when Judge Bev declared a mistrial. Regardless of that, what is the court going to do now, knowing, and as Judge Bev said herself, that they are true and accurate, knowing that there were verdicts on counts 1 and 3, and those verdicts were not guilty. And so that's what the defense is like trying to push. They're trying to stress, like there were verdicts. We can argue that the court itself did not follow the rule, and we can also argue that the court itself did not provide an opportunity for comment. And we can also argue that Judge Bev, while she says that it's true and accurate that there were verdicts on count 1 and 3, Judge Bev is still choosing to not dismiss counts 1 and 3 because Judge Bev is focusing on the form. She is trying to obfuscate the argument and just make everyone focus on the form when she herself did not focus on her form. She did not follow the form. She did not follow the procedures. So I'm saying like Judge Bev's hands are dirty, and that's a legal term. That's a legal phrase. She has dirty hands here in that she herself didn't follow the rules. She herself didn't follow the form. So why then is Karen Reed being forced to follow the form when the court itself, the judge herself, did not follow the form? There is room here. There is room here to hold Judge Bev accountable for what happened. And there is room here. There's still time here to bring the jury back for a post-trial meeting to make sure that if in fact they found Karen Reed not guilty on count 1 and 3, then Karen Reed should not be retried on count 1 and 3. So again, the defense is pushing it from an angle that is in Karen Reed's best interest, whereas the prosecution and the judge herself are pushing it from an angle that says who cares? Who cares what the jury says? Who cares if there were verdicts? We need to retry her. We need to do this all over again. The prosecution and the judge would rather waste more energy, more resources, and more time and subject Karen Reed to more harm and more unnecessary stigma in all this and unnecessary suffering in all this. Even though the judge and the prosecution were not careful, even though the prosecution itself and the case they brought forward was sloppy, it was sloppy and almost laughable if it wasn't so corrupt, blatantly and overtly corrupt. Even though like they get to fuck around, Karen Reed is not allowed to have an exception here. It's like that's what the judge and the prosecution are saying. Karen Reed is not permitted to be an exception here. Just the bias from the beginning of the trial to the end of the trial and now post-trial. That bias is thick. It is strong. It's prevailing. And the defense is just saying like please, like look at what's happening to our client. Look at what's happening to Karen Reed. Look at all these holes that shouldn't have been there. Look at all this sloppy, look at this mess that shouldn't be this way. And yet we have verdicts. All right, continuing to read. Just going to skip that one. All right, next section. Here, the affidavits by attorneys Jackson and Unetti reflect statements by 5 deliberating jurors that the jury had reached a final unanimous conclusion that Miss Reed is not guilty of counts 1 and 3. There was nothing tentative about these jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. See affidavit. Quote, Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime, end quote, and provides the affidavit. Reflecting text message from Juror B, quote, it was not guilty on second degree. No one thought she hit him on purpose or even knew that she had hit him, end quote. Juror C's statement relayed by intermediary C that there was, quote, no consideration for murder, 2, end quote, and Miss Reed, quote, should have been acquitted, end quote, on that count. Supplemental affidavit of Alan J. Jackson, quote, Juror D, without hesitation, said in substance, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3, because that's what happened, end quote. Second supplemental affidavit, quote, Juror E explained that the jury was unanimous on 1 and 3, that Karen Reed was not guilty of those charges, end quote. As noted above, the trial court accepted the foregoing averments. It was blurry for a second. Averments as true facts. Yes, she did. True and accurate. That's what Judge Bev said. Continuing to read. In rejecting Miss Reed's claim of acquittal, the court relied solely upon the lack of an, quote, open and public verdict affirmed in open court, end quote. And just pulling away like that is truly all that Judge Bev had in her filing. That is truly the sole argument, the main at the core, like that was her argument. That's what she hung her hat on. It wasn't a verdict because it wasn't announced in open court. And she took zero responsibility for the fact that there were no verdicts announced in open court. Rule 27B is specific. It is a permission. It says that the judge may declare a mistrial. It gives the judge permission to declare a mistrial, but that she must first require the jury to give her any verdicts that they did agree on. So she was supposed to require the jury before she declared a mistrial. She was supposed to ask them if there were any verdicts that they did agree on, and she did not. And again, Judge Bev was permitted to have discussions with the foreperson privately. According to jurors who came forward and were interviewed by Aidan Kearney, those jurors were not permitted to speak with Judge Bev. Only the foreperson was permitted to speak with Judge Bev. So again, like there is stuff there that went down and Judge Bev is taking zero responsibility. She is being a snake. She is being a snake in how she is so uncaring as to what happens to Karen Reed. She is so uncaring about the facts of the case. And she is so uncaring of those jurors despite her pretending to care about them during trial. All right, continuing to read. This reasoning is rooted in a formalism that has been consistently rejected by the United States Supreme Court and this court in a string of precedents spanning more than 100 years. So what the defense is saying here is that for Judge Bev and for the court to focus solely on the form, it is a reasoning that has been consistently rejected by the United States Supreme Court and the appellate court. That you can't focus on the form. You have to value what's right and wrong. You have to put justice before the form, and to me, the judge has to acknowledge that there were holes there, that she didn't make sure the safeguards were followed through, She didn't make sure the safeguards were in place, and therefore there were holes. And because there were holes, we didn't know that the jury had verdicts, and the jury didn't know that they were supposed to tell the court that they had verdicts. That's why immediately the day after Judge Bev declared a mistrial, immediately the day after, the jury members came forward and said, what about those verdicts? And, and I remember when the judge declared a mistrial, she said, I will meet with you in my chambers or something like that. She was going to meet with the jury before they went home that day. So they had the opportunity to tell her then too. So I'm just saying, guys, this is a strong argument that the defense has here, and they are correct. They are correct. The judge was imperfect here. There was room for improvement here. And because she erred, she didn't do her job, she should honor those verdicts. But she is choosing not to. She's, again, if you read her filing, she does not take any responsibility for what happened, despite her not following the rules. She does not take any responsibility. She simply puts it back on the defense and says, it's your damn fault that there were no verdicts announced in open court. That's what she does, even though, again, there is a rule that gave her the permission to require the verdicts be spoken in open court. She puts it back on the defense. She takes zero responsibility for her error and, to me, her corruption in declaring that mistrial. Continuing to read. All right, hang on. I'm going to make sure I didn't miss anything. Okay. Quote, however it may be in England, in this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense, end quote. Provides a case law holding that judicial grant of new trial prohibited retrial in double jeopardy grounds, notwithstanding that the state quote, Code of Criminal Procedure did not authorize trial judges to enter judgments of acquittal in jury trials, end quote. Indeed, under the trial court's reasoning, affidavits executed by all 12 jurors attesting to a final unanimous decision to acquit would not be sufficient to mount a successful double jeopardy challenge. Surely that cannot be the law. Indeed, it must not be the law. Again, these are similar statements they made in their motion for relief. Continuing to read, and in the context of this highly publicized case, it strains credulity to suggest that if the unequivocal statements of the 5 jurors quoted above did not in fact represent the unanimous view of all 12, the remaining jurors would allow the inaccuracy to go uncorrected. Instead, they would predictably have notified the Commonwealth or the court of their own recollection. Here, to the contrary, the Commonwealth has received the exact same information as the defense regarding the jury's unanimous agreement to acquit Miss Reed on counts 1 and 3. The United States Supreme Court's decision in Bluford is not to the contrary, as it is factually distinguishable from the instant case. There, the foreperson had reported during deliberations that the jury, quote, was unanimous against, end quote, the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the Double Jeopardy Clause prohibited a reprosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality for the juror's report. quote, the jury's deliberations had not yet concluded, end quote, and it, quote, went back to the jury room to deliberate further, end quote. Quote, the four-persons report was not a final resolution of anything, end quote, and there was no indication at the conclusion of deliberations that, quote, it was still the case that all 12 jurors believed the defendant was not guilty of capital or first-degree murder, end quote. Here, by contrast, the jurors' statements reflect a final and indelible determination that persisted through the end of deliberations and following. The contrast with a juvenile versus Commonwealth is even clearer. In that case, after the conclusion of trial, a court officer found 4 verdict slips in the deliberation room, 2 of which reflected entries of, quote, not guilty, end quote. There was no indication as to when the entries were made or in what circumstances, much less that they reflected a final unanimous conclusion of all jurors. Neither the Commonwealth nor the trial court has cited any case in which a defendant was forced to stand trial a second time for an offense a previous juror had found her not guilty of, simply because such final unanimous agreement was not announced in open court. Yeah, so I made that argument when I read their motion for relief as well, that's an excellent point. It's an excellent point that the Commonwealth nor the judge nor the court provided any case law that says that they don't have to acknowledge it because it wasn't announced in open court. Anyway, continuing to read. Arguing that Commonwealth had not cited, quote, a single case with facts like this that have been ignored, not a single precedent have they raised nationwide state courts murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, but she was acquitted, end quote. The instant case squarely presents that issue, and the defense respectfully submits that this court should hold that any lack of formality does not supersede the defendant's fundamental constitutional protections. This is one of existential importance, not merely to Miss Reed, but to the very foundation of the constitutional safeguards that protect her. I'm sorry, guys. I'll read that again. This issue is one of existential importance, not merely to Miss Reed, but to the very foundation of the constitutional safeguards that protect her. Number 2, alternatively, the defense is entitled to a post-verdict judicial inquiry to determine whether the evidence supports the juror representations as to having acquitted Miss Reed. The trial court was wrong to artificially limit the right to a post-trial inquiry to develop a substantial claim of a constitutional violation to the narrow context of claims implicating, quote, racial bias, end quote, or the, quote, right to receive an impartial trial, end quote. Order at 20, the court has not framed the availability of post-trial inquiry so narrowly, instead stating, quote, we will permit juror testimony regarding overt factors by which the verdict's validity can be objectively assessed, end quote, such as extraneous influences on the jury, but not regarding the subjective mental processes of jurors, such as the reasons for their decisions, end quote, provides the case law. In Fiddler, this court rejected, quote, the Commonwealth's suggestion of an inflexible rule excluding all juror testimony offered to impeach verdicts, end quote, as, quote, achieving stability at the expense of doing justice between the parties, end quote. Instead, the court ruled where the defendant's claim is predicated upon the presence of, quote, overt factors, end quote, quote, the law's commitment to a just result warrants receiving evidence, but where the juror would testify solely to matters resting in his own consciousness, the dubious value of the testimony is outweighed by the need for stability in verdicts, end quote. Fiedler expressly, quote, recognized that the line between overt factors and matters resting in a juror's consciousness is not easily drawn and difficult cases will arise, end quote. But it went on to observe, quote, we think it possible to draw the line in most cases, and in any event, the better course is to try to do so rather than refuse to try, end quote. The law is clear that in the context of, quote, juror bias, end quote, an affidavit by counsel is sufficient to entitle the defendant to a, quote, post-verdict inquiry on the issue. So just to stop it here, that the defense has so far cited case law saying that because they provided affidavits by counsel, by Karen Reed's lawyers, they were by case law, they should have been permitted to have a post-verdict inquiry. And they were not. So despite their legal arguments, Judge Bev is not budging. Judge Bev is not budging. She will not do the right thing. It continues, if, quote, the credibility of the affidavit is an issue, the trial judge should conduct a hearing to determine the truth or falsity of the affidavit's allegations, end quote. In so holding, this court stated, quote, where a defendant submits a motion raising the possibility that she did not receive a trial by an impartial jury, which was her fundamental right, it could not be ignored, end quote. No less than the right to an unbiased jury, it is, quote, a fundamental tenet of our system of justice, end quote, that a defendant may not be retried for a crime of which she was previously acquitted by a jury, and the defense submits that post-verdict inquiry is equally warranted in the present context. Other than generally noting that the present case does not involve an allegation of juror bias, the trial court did nothing to distinguish the legal basis and justifications in McCaleb from those raised herein by the defendant. The defense respectfully submits that the court should hold that the presence of an unannounced verdict supported by the unambiguous post-trial statements of 5 deliberating jurors constitutes an, quote, overt factor, end quote, at least entitling the defense to further inquiry. Fiedler provides case law. Quote, during an inquiry into the validity of a verdict, the court may ask the jurors individually to affirm publicly that the verdict as recorded represents their decision, end quote, permitting juror testimony that, quote, a mistake was made in entering the verdict on the verdict form, end quote, given the foundational importance of jury acquittals in our justice system. This is a circumstance in which the law's commitment to a just result warrants receiving evidence, end quote, provides the case law. Recently, in United States versus, I think, Sarnave, the First Circuit Court of Appeals remanded the matter for further proceedings in the Boston Marathon bombing case due to 2 jurors' postings on social media, quote, regarding the bombings and the district court proceedings, end quote, which came to light after the jurors had been provisionally selected to serve. the comments did not reflect racial bias in any way, but rather possible bias specific to the defendant. The comments were also inconsistent with the jurors' assurances that they had not discussed the case online. The First Circuit held that the district court erred by failing to inquire about these issues with the jurors, given that, quote, the right to an impartial jury is a constitutional bedrock. When there is a plausible claim that a prospective juror lied in a manner that may reveal bias, a court need conduct some inquiry reasonably calculated to determine whether the prospective juror did lie, and if so, why, end quote. Crucially, for present purposes, the First Circuit ordered the district court to voir dire the jurors. In doing so, the court acknowledged, quote, no doubt any juror would have strong incentives to avoid admitting having committed perjury during voir dire. We also expect that most jurors, having taken time out of their daily lives to receive evidence at trial, deliberate with other jurors, and reach a verdict that they believe is just, would prefer not to have that verdict disturbed, especially as a result of their own actions. We have no doubt that the able district court judge can do what judges regularly do, form a considered opinion about the sufficiency of the jurors' explanations once those explanations are given and explored, end quote. Likewise, the experienced trial court in the matter sub judice, I think it's Latin, can, after conducting an appropriate judicial inquiry, make findings as to whether, in fact, Miss Reed was acquitted. And I think it's Latin for, like after sub judice. Yeah, it's almost like saying post-trial. Okay. Continuing, in another high-profile case, the South Carolina Supreme Court recently agreed to hear claims by Alex Murdaugh that during his murder trial, the clerk of the court improperly influenced deliberating jurors, provides the case law. Jurors came forward after the clerk published a book about the trial describing her, quote, efforts to obtain, quote, a, quote, guilty verdict through improper jury tampering, end quote. Brief of appellant provides case law. It's an attachment. Okay, continuing to read. The clerk allegedly told jurors after the defense began its case, quote, not to let the defense throw you all off or distract you or mislead you, end quote, and warned them, quote, not to be fooled by Mr. Murdaugh's testimony in his own defense, end quote. The trial court held an evidentiary hearing on the motion for new trial, including testimony by jurors. The issue was not racial bias, but nonetheless implicated fundamental constitutional rights like Miss Reed's right not to be retried for offenses of which she has already been acquitted. All right, continuing. So I get their argument here that in the Alex Murdaugh case, which again is the same argument they provided in their motion for relief, the jury were permitted to be brought back for an evidentiary hearing, and it had nothing to do with bias. So the defense, Karen Reed's defense team is saying, like, well, that case didn't have anything to do with bias, and the jurors were able to come in. And this case, Karen Reed's case, doesn't have anything to do with bias, jury bias. We're just saying, can we bring the jury back in? Because the jury are telling us that they had verdicts. So I think it's a perfectly fair, reasonable argument. Anyway, continuing to read. The trial judge dismissed Miss Reed's reliance upon Charnave and Murdaugh in a brief footnote, simply stating that the circumstances, quote, are readily distinguishable, end quote, from those at issue here. Provides the attachment. But this misses the forest for the trees. While it is certainly true that all three cases raise different issues, the fundamental point remains the same. A defendant who comes forward with credible evidence of a serious constitutional violation post-trial must be entitled to an opportunity to prove those claims. There is no apparent reason to artificially limit the availability of such constitutional inquiry to the singular context of racial bias, as the trial court suggested. So, pulling away what the defense is saying, that the cases they have listed so far, there's a point to all of them, and it's that Karen Reed has a constitutional right to have a post-trial hearing, to figure out if those verdicts are valid. And we already know that they are, even through Judge Bev. As corrupt as she is, we already know that those verdicts are valid because she considered those verdicts true and accurate, but she refuses to dismiss Karen Reed's charges, counts 1 and 3, despite her considering those verdicts true and accurate. So anyway, I think it's a valid argument. It's the second argument they have in their motion for relief, and they are, to me, it's the strongest argument they have. Yeah, I mean, to me, if the Supreme Court denies their second reason, then yeah, I mean, they had better have really good argument for denying that reason. Just saying. All right, continuing to read. The defense request does not in any matter infringe upon, quote, the substance of the jury's deliberations, end quote. To the contrary, the motion to dismiss was predicated solely upon the result of such deliberations, namely a unanimous decision that Miss Reed is not guilty of murder in the second degree. The relevant inquiry could be accomplished by a single. Okay, sorry, had to pause it for a minute. The relevant inquiry could be accomplished by a single yes or no question posted to jurors. Did you unanimously acquit Karen Reed of the charges in counts 1 and 3? Of course, the results of a jury's deliberations are not secret. They are, in fact, routinely announced in open court. Here, the defense has learned, post-trial, that the jury reached a verdict that was not so announced. It was at least entitled to the opportunity to substantiate that fact in order to ensure Miss Reed is not unconstitutionally forced to stand trial for criminal offenses of which she has already been acquitted. Such inquiry is in no way intrudes on the deliberative process of the jury. Such an inquiry instead honors the jury service, which the trial court described as, quote, extraordinary, rather than disregarding the efforts of 5 jurors to disclose that there was not an, quote, impasse, end quote, on all 3 as contrasted to only 1 count. Really good argument, and I've made that exact same argument in previous videos. That if the judge really felt like, if the judge really cared about the jury like she pretended to during trial, then she would continue to honor the jury's wishes post-trial. But it's clear that all she was doing during trial was a front. She was faking caring about the jury. She was faking caring about her job. And post-trial, she is faking caring about what is or isn't ethical. She's a liar. Continuing to read. Indeed, it was the trial court, not the defense, that injected issues regarding jury deliberations into the inquiry. It is simply not true that, quote, given the content of the jury's final note to the court, any inquiry would necessarily require the court to understand why the jury's final note communicated a deadlock on charges. when post-trial, certain deliberating jurors are purportedly stating that the jury was in fact unanimous on most of the charges, end quote. As explained in pages 45 to 46, in light of the trial court's instructions repeatedly characterizing the lesser included offenses within count 2 as discrete charges, the jury's note is readily susceptible to interpretation consistent with the post-trial evidence supporting the defense motion. In any event, if the jurors state that they acquitted Miss Reed, no further inquiry regarding the contents of the jury note could possibly remove the clear constitutional implications of such acquittal. Really nice way to close that argument. And number 3, re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was not deadlocked. Absent the defendant's consent, quote, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction, end quote. Provides a case law quoting Washington. This rule is rooted in, quote, the importance to the defendant of being able, once and for all, to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate, end quote, provides the case law. See also Taylor. Quote, the double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Quote, thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. And that's a solid case to cite. I'm pulling away from their argument here. It's a solid case law to cite that they're saying because Karen Reed did not consent to the mistrial, she wasn't given the opportunity to consent to the mistrial. There is a case law that says that she can't be retried. It's impermissible unless there was manifest necessity for the mistrial. And again, the defense is arguing that there was no manifest necessity. And again, that the last jury note was obviously about count 2. It was not about the other 2 counts, because obviously the judge herself considers that the jury had verdicts on counts 1 and 3. Again, it's like what it is too, guys. It's like a circular argument between like an old married couple who like just it's like a circular argument that goes nowhere. And what's really happening is that the one person is trying to do the right thing and the other one wants to keep arguing. Like that's what's going on here. The defense is trying to do the right thing, but Judge Bev and the prosecution, they just want to keep arguing. They just want to keep going in circles. They don't want to do the right thing with the information that they have, with the information that the judge herself considers true and accurate. You know, it's an endless circular argument, all intended to make sure that they are able to retry Karen Reed in January. Continuing to read, importantly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth, provides the case law. And this burden remains solely upon the Commonwealth regardless of whether or not a defendant objects to the declaration of a mistrial. Before a court declares a mistrial for manifest necessity, quote, 1, counsel must have been given full opportunity to be heard, and 2, the trial judge must have given careful consideration to alternatives to a mistrial, end quote. Here, the defense respectfully submits that the lack of opportunity to be heard alone is dispositive. Upon receiving the final jury note, the court declared a mistrial and excused the jury without consulting counsel. This action, quote, was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. They provide the case law. Finding no manifest necessity where, quote, no opportunity was given counsel to argue the propriety of the question or of the necessity of a mistrial, end quote. Finding no manifest necessity where the, quote, where, quote, the trial judge first ruled that he was going to declare a mistrial and then almost as an afterthought unenthusiastically asked whether counsel objected, end quote. The defense was provided no opportunity to object to the declaration of a mistrial or to advise the court of the imperatives of the Rule 27B and request that the jury be polled or discuss the issue with Miss Reed. The defense respectfully submits that, given the importance of double jeopardy protections and the profound implications of a retrial for a criminal defendant, an opportunity to be heard must, in order to be meaningful, occur after a reasonable opportunity for counsel to consult with their client. Arguing that counsel had, quote, no opportunity to speak to Miss Reed. After all, it's her rights, not theirs. Counsel for Miss Reed clearly had no such opportunity here, whether or not the trial court was obligated to obtain Miss Reed's personal consent. Its failure to at least ensure that counsel had an opportunity to consult with Miss Reed on the issue undermines the existence of manifest necessity. The record is independently lacking on the second prong, as it reflects no, quote, careful consideration, end quote, of, quote, alternatives to a mistrial, end quote. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked. This option is apparent from the face of the Massachusetts Rules of Criminal Procedure, Rule 27B, which states that, quote, the judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded, end quote. In fact, the reporter's notes expressly indicate that such reception of partial verdicts is required before a mistrial may be declared for manifest necessity. Exactly. Again, it's a rule. It's a rule in the state of Massachusetts. Just so happens for the criminal court. Just so happens in this criminal case. Just so happens, but Judge Bev completely ignored it. Okay, continuing. Quote, this rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. Exactly. Yes, exactly. Must first. All right, continuing. Had the court inquired as to the existence of any partial verdicts and the jury articulated its verdict consistent with the statements of Juror A, Juror B, Juror C, Juror D, and Juror E, the double jeopardy implications would have been clear and decisive. Quote, indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict, end quote, provides the case law. quote, when the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached agreement, end quote. In denying the motion to dismiss, the trial court erred by relying primarily upon the lack of objection by defense counsel. In doing so, it utterly neglected to acknowledge the clear and long-standing case law, placing the burden of establishing manifest necessity squarely on the prosecution. Nicole provides a helpful analog. The defendant in Nicole was charged with operating a vehicle under the influence of alcohol. Only 6 jurors were impaneled, and after the trial began, one juror recognized a witness, quote, and informed the trial judge that he might not be able to be impartial, end quote. The judge excused the juror. Quote, left with 5 jurors, the judge and attorneys briefly discussed how to proceed. Defense counsel expressed his frustration over the impanelment of only 6 jurors and then stated, quote, I don't think we can go forward with the 5 jurors, can we? End quote. The judge responded, quote, not in a criminal case. Okay, I'm going to declare a mistrial, end quote. After a retrial was scheduled, the defendant moved to dismiss on double jeopardy grounds. The trial judge allowed the motion, finding, quote, that contrary to his initial understanding, Massachusetts procedural rules would have allowed the trial to continue with 5 jurors, albeit with defendant's consent, end quote. The judge therefore found that he, quote, had failed to give careful consideration to the alternative of proceeding with the trial before less than a full jury, end quote, and accordingly, quote, there had been no manifest necessity for the mistrial. So I get why they're citing that case in their arguments. They're essentially saying that the judge, realizing that his error, agreed to dismiss on the grounds of double jeopardy because the judge himself declared a mistrial, right? Yeah, declared a mistrial. And realized that he declared a mistrial unnecessarily. But Judge Bev herself is not doing that. She's not a judge with integrity. She's not saying, I declared a mistrial unnecessarily. I'm going to do my job. I'm going to do it the right way. She just so badly wants to retry Karen Reed. And that is clear to all of us who are paying attention. Continuing to read, on appeal, this court began from the premise that, quote, due to the importance of the double jeopardy protection, the Commonwealth bears the heavy burden of proving that a mistrial rested on manifest necessity, end quote. The court then agreed with the trial judge. Hang on. I'm going to read that again. Due to the importance of the double jeopardy protection, the Commonwealth bears the heavy burden of proving that a mistrial rested on manifest necessity. Okay, just making sure I read that correctly. The court then agreed with the trial judge that the defendant could waive his right to a trial by a jury of at least 6. It rejected the Commonwealth's argument that the defendant in the case at hand had not provided such a waiver, observing, quote, the question is not whether a defendant executed a valid waiver, but whether there was a manifest necessity for declaring a mistrial. Such a necessity would have presented itself if defendant had declined to execute a waiver, but the record is clear that neither the judge nor counsel was aware of or even considered the option, end quote. Quote, in these circumstances, the Commonwealth was unable to satisfy its heavy burden of proving that there was a manifest necessity for declaring a mistrial. The defense respectfully submits that the same result is required here. It is the prosecution's burden alone to ensure that the declaration of a mistrial is supported by manifest necessity, even where, unlike in the present case, defense counsel was expressly offered the opportunity to be heard on how to proceed and explicitly shared the judge's mistaken view that the trial could not continue with fewer than 6 jurors, this court held that the alternative to declaring a mistrial was not adequately considered. Here, there is no doubt that the court was permitted to accept a partial verdict, but the record simply reflects no consideration of that option. Accordingly, as the Nicole, the charges in this matter must be dismissed. Neither Miss Reed nor her counsel consented to the declaration of a mistrial. Consent may be implied, quote, where a defendant had the opportunity to object but failed to do so, end quote. But the law is clear that such consent may not be inferred from counsel's silence alone, provides the case law. Commonwealth versus Edwards. Quote, the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed, end quote. Holding that where, quote, the trial judge did not ask defense counsel to comment on the possible declaration of a mistrial, end quote. Quote, the lack of an objection from defense counsel cannot be construed as consent to such action. Here, no such consent was sought, nor was it given. So, again, the defense backfires with the prosecution and the judge's case law that they cited. The case law that they cited was that if no objection is made during the declaration of a mistrial, then consent can be assumed, it can be implied. But again, the defense is backfiring with another case law saying that the lack of an objection from defense counsel cannot be construed as consent. So it's, like I said, they provide case law that tends to override the case law that Judge Bev and the prosecution provided, that they're relying on in order to keep pushing and retry Karen Reed. Continuing to read, the trial court's ruling that Miss Reed's counsel impliedly consented to the mistrial was based primarily upon counsel's request for a Tui Rodriguez instruction. Of course, whether the jury has engaged in, quote, due and thorough deliberation, end quote, to support a Tui Rodriguez instruction, and whether there is manifest necessity to declare a mistrial are distinct legal questions. In fact, the Tui Rodriguez charge is, quote, designated to urge the jury to reach a verdict, end quote, not to avoid one, provides the case law. Unsurprisingly, neither the Commonwealth nor the trial court cited any case finding a defendant's consent to a mistrial can be based on a prior request for a Tui Rodriguez charge. And again, they used this argument, pulling away from the filing, they used this argument during their motion for relief, and it was an excellent argument. I called it the uppercut argument, that how can the judge be construing Tui Rodriguez as permission to declare a mistrial when Tui Rodriguez has nothing to do with a mistrial. Tui Rodriguez is merely an instruction. And again, the judge used it as an alternative. And she almost convinced me, like, yeah, maybe it's an alternative. But in fact, it wasn't an alternative. It was merely an instruction. In fact, people, Judge Bev provided no alternatives to declaring a mistrial. No alternatives. And again, she didn't follow any rules. Okay, continuing to read here, defense counsel's request did not reflect any implicit concession that the jury was deadlocked on all counts, nor did they commit the defense to any position regarding whether the court should sua sponte declare a mistrial. And as I said in the previous video, sua sponte means on its own. A court, it's when a judge makes an order on her own, on his or her own, without a motion. They can even do this without a motion. The judge can Just say, I'm making an order sua sponte. I'm doing this on my own. And that's exactly what Judge Bev did. She declared a mistrial on her own. I have argued this repeatedly. Repeatedly, I have said Judge Bev declared a mistrial on her own terms. Continuing to read, it is true that if the jury reports an impasse after a Tui Rodriguez instruction, they, quote, shall not be sent out again without their own consent, end quote. That fact, however, does nothing to undermine the alternative of simply inquiring pursuant to Massachusetts Rules of Criminal Procedure Rule 27B, whether the jury had reached any partial verdict. Doing so would not require the jury to be, quote, sent out again, end quote. The trial court was in error in equating a request for a Tui Rodriguez charge with any acceptance of or acquiescence to a mistrial. Really good arguments here. Continuing. Moreover, the trial court's characterization of the jury's final note as, quote, making it clear that the jurors would not consent to continuing their deliberations, end quote, is belied by case law cited in the court's order. Provides the case law. The jury similarly reported after a Tui charge, quote, that they felt strongly that there was no hope of progress and requested further instructions, end quote. The court responded by telling the jury, quote, I cannot force you to continue deliberations unless you agree to continue deliberations, end quote. But then asking them, quote, to retire and decide whether further deliberations on the next day would be fruitful, end quote. The jury, quote, promptly reached a verdict, end quote. This court held that, quote, the object of, end quote, the statutory prohibition on sending the jury back out without consent, quote, was fulfilled because the jury consented to continue their work. The jury's return of a verdict after sending their last note implicitly satisfied the statutory requirement of jury consent, end quote. Thus, another alternative to a mistrial, which the trial court did not consider in this case, would have been to A, inform the jury that it could not be required to continue deliberations without its consent, and B, ask it to retire to consider whether it was prepared to return any partial verdicts. Yes. Yes. Again, they used this argument in their motion for relief, and those were actual alternatives to a mistrial, neither of which Judge Bev considered. Continuing to read. Here, neither Miss Reed nor her counsel were provided an opportunity to object to the declaration of a mistrial, as opposed to the appropriateness of a Tui Rodriguez instruction. All of the cases cited by the trial court on this issue are readily distinguishable on that basis. For example, in Pellegrin, a witness testified at trial to incriminating evidence that had not been disclosed to the defense. This court held that the defense had an opportunity to object given that, quote, the mistrial was declared after a voir dire of the witness and colloquy after the jury were cleared from the courtroom, end quote. Here, by contrast, the defense did not learn of the contents of the jury note or the court's intention to declare a mistrial until the judge called the jury in and stated the declaration of mistrial on the record. Counsel was never shown the note from the jury. The judge indisputably never informed counsel of its intent to declare a mistrial, much less solicited counsel's views on the matter. Provides a case law to compare to, ruling in case where, quote, defense counsel at one point implored the district court to declare a mistrial because the jury was deadlocked, end quote. Quote, it would be and wrong to allow parties freely. It would be wrong to allow parties freely to advocate on appeal positions diametrically opposite to the positions taken by those parties in the trial court, end quote. Provides the case law. And after co-defendant moved for mistrial, the, quote, court subsequently stated that it was going to declare one, end quote, and, quote, asked the attorneys if either wished to make any record, end quote, provides the case law. Quote, defendants had moved for a mistrial a scant 2 hours before one was declared at the first suggestion of jury deadlock, end quote. As the appeals court has explained in an sorry, I said this before, analogous. It's weird. Me reading that, it's just, okay. Factual context, the suggestion that counsel could or should have immediately objected to the sua sponte declaration of a mistrial, quote, underestimates or ignores the difficulty of reaching a decision in which the defendant has an evident personal stake, whether the defense would be advantaged or the opposite by a second trial. The possibilities ahead, such as the appearance of a new prosecution witness, cannot be instantly calculated. Therefore, to equate silence with consent when the occasion comes abruptly and unexpectedly seems quite unwise, end quote, provides case law. The trial court's suggestion that defense counsel had an opportunity to object to the declaration of a mistrial after it had occurred and the jury had been discharged is mistaken. The judge expressly told jurors, quote, your service is complete. I am declaring a mistrial in this case, end quote. Given counsel's lack of an opportunity to be heard and the court's lack of consideration of alternatives, the defense respectfully submits that the prosecution has not satisfied its high burden of establishing manifest necessity for the mistrial. While the trial court correctly observed that jury deadlock may be grounds for a mistrial, it cited no precedent for the counterintuitive proposition that a deadlock with respect to some but not all counts constitutes manifest necessity for the declaration of a mistrial as to all, and provides case law to compare to. Affirming declaration of mistrial where note expressly, quote, stated that the jury could not reach a unanimous verdict as to either, end quote, of the two indictments. This lack of precedential support is no accident. Such a rule would run counter to the important interests underlying the constitutional safeguards against double jeopardy. Contrary to the trial court's suggestion, there was nothing in the jury's notes that directly contradicted the post-trial affidavits by counsel. As an initial matter, there is a facial tension between this observation by the court and its stated acceptance of the affidavits as true for purposes of the motion to dismiss, and the jury's reference to charges is easily reconciled with the post-trial affidavits, affirming that the only deadlock related to the lesser included offenses of count 2. Indeed, the court repeatedly referred to those lesser included offenses as distinct charges, both in its initial and supplemental instructions to the jury. In this context, the jury's note was facially susceptible to two alternative interpretations. One, that the jury had reached an impasse as to all charges, or two, that the deadlock applied to only some of those charges on multiple lesser included allegations within a single count, such as count 2. The information received from jurors post-trial proves the latter interpretation was correct. Right, so just stopping and pulling away, the defense is saying, as they have said in their motion for relief, is that there could have been two interpretations of the final note, the impasse note, that preceded the judge's declaration of a mistrial. There could have been two interpretations of that note. The first being that the jury had reached an impasse on all charges, that they couldn't decide on all charges, or the second interpretation is that they were deadlocked. They were hung only on some of those charges, and count 2 had multiple lesser included allegations. And that post-trial, we all know now that the information received from the jurors proves the latter interpretation was correct. Yeah, it just, again, it was certainly a rush to a mistrial. To me, there is no denying that there was a rush to a mistrial. And again, I really hope the appellate court sees it that way. They have to see it that way. Multiple things were violated, and there were multiple interpretations of that note. And again, the judge herself acknowledges those verdicts as true and accurate. I mean, we know that Judge Bev is not going to do the right thing here. So I am praying that the Supreme Court, the appellate court, does the right thing. All right, continuing to read. The jury's failure to expressly mention its agreement on counts 1 and 3 is understandable in light of the court's instruction that it, quote, should continue deliberating until, end quote, it had, quote, reached a final verdict on each charge, end quote, June 25th, 2024. This court's holding in Commonwealth versus Roth that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. Roth was rooted in the belief that, quote, inquiry concerning partial verdicts on lesser included offenses, end quote, that have not been separately charged, quote, carries a significant potential for coercion, end quote, provides the case law, declining to require court, quote, to consider giving the jury new options for a verdict, end quote, in the form of partial verdicts on lesser included offenses where, quote, under Arkansas law, the jury's options were limited to two, either convict on one of the offenses or acquit on all, end quote. Such inquiry and effort implies that the jury should consider conviction on the lesser count. No similar danger is present where, as here, the jury was asked to return 3 separate verdicts on 3 separate counts. Distinguishing situation, quote, where a defendant has been charged in separate indictments or complaints, each with a separate verdict slip, end quote. Quote, where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts despite deadlock on the other counts. In this circumstance, end quote. In this circumstance where the jury reports a deadlock without specifying the counts on which it has reached an impasse, it is a straightforward and, the defense contends, constitutionally required follow-up to ask whether the deadlock relates to some as opposed to all counts. Contrary to the trial court's suggestion, an inquiry regarding whether the jury had reached a partial verdict on any of the 3 separately charged counts would not necessitate any forbidden inquiry on the lesser included offenses contained within count 2. There is simply nothing coercive about asking a jury reporting a deadlock that fails to specify which counts the deadlock relates to. The single question of whether its deadlock is on certain but not all counts, and if it has reached a unanimous verdict on any counts, provides a case law affirming trial judges taking of partial verdicts on 2 of 4 separate indictments and observing, quote, to conclude that the jury could have felt pressured to convert provisional verdicts against the defendant into final ones and to abandon all doubts that they may have privately entertained, runs counter to the clear instructions of the judge and the amounts to mere speculation. And amounts to mere speculation without any support in the record, end quote, provides the case law. Noting in the context of deadlock jury that Rule 27B permits taking verdicts on less than all of the charges set forth in separate indictments, end quote, provides the case law. Affirming partial verdicts taken after judge asked whether it had, quote, reached a verdict on any of the indictments, end quote. The inflexible prohibition on judicial inquiry regarding partial verdicts advocated by the Commonwealth would inevitably undermine defendants' important and constitutionally protected interest in, quote, being able once and for all to conclude their confrontations with society through the verdict of a tribunal they might believe to be favorably disposed to their fate, end quote, provides the case law. And, quote, the danger of unfairness to the defendant from, end quote, from multiple prosecutions, quote, exists when a trial is aborted before it is completed, end quote, as well as when the defendant is actually acquitted, provides the case law. The Commonwealth's proposed rule would also undoubtedly hinder law enforcement interests by precluding courts from asking whether a jury may have reached a guilty verdict on some, but not all, standalone counts. Interesting argument there. Okay, continuing to read. It is uncontroverted that, according to the jury of her peers following trial, Miss Reed was unanimously found not guilty of counts 1 and 3, that undisputed fact must not be lost in this analysis. It bears repeating that, quote, at the heart of this policy against double jeopardy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression, end quote. And number 4, assuming arguendo, this court finds that counsel consented to the mistrial, the defendant's personal consent was required. The defense respectfully submits that whether to consent to a mistrial and risk the prospect of retrial should be a decision for the client who must bear the consequences, provides the case law. Quote, some basic trial choices, end quote, including the choices, quote, to plead guilty, waive a jury, testify in her own behalf, or take an appeal, end quote, are so important that an attorney must seek the client's consent in order to waive the right, end quote, provides the case law. Holding defendant waived double jeopardy where, quote, after consultation with counsel, the defendant elected to accept the offer, end quote, of a mistrial. But see Daniel versus Commonwealth. The Supreme Court has recently shifted the balance, quote, of power between counsel and client, end quote, regarding fundamental decision-making in criminal cases, provides a case law. Assuming arguendo, the court finds that counsel consented to the mistrial here. The defense contends it should additionally address whether the decision to forego a jury verdict is among the fundamental questions that must be decided by the client, as urged by the defendant in the court below and in this appeal. Conclusion. For the foregoing reasons, Miss Reed respectfully requests that this honorable court reverse the trial court and order counts 1 and 3 dismissed. Respectfully submitted for the appellant, Karen Reed, by her attorneys, Martin G. Weinberg, and Michael, Allen, and David, September 24, 2024, and Addendum, Commonwealth of Massachusetts, Memorandum of Decision and Order on Defendant's Motion to Dismiss. Okay, on June 9th, 2022, a Norfolk County grand jury indicted defendant Karen Reed on charges of murder in the second degree, indictment 1, manslaughter while operating under the influence of alcohol, indictment 2, and leaving the scene of personal injury and death, indictment 3, Following the death of her boyfriend, John O'Keefe, on January 29th, 2022, trial on the matter began in April 2024. There were 8 weeks of evidence and nearly 5 days of deliberations after the jurors expressed to the court that they were deadlocked for a third time. The court declared a mistrial. The defendant now moves to dismiss the charges for murder in the second degree and leaving the scene of personal injury and death, arguing that retrial would violate the double jeopardy protections of the federal and state constitutions because the jury in fact reached a unanimous decision to acquit the defendant on those charges. Alternatively, the defendant argues that dismissal is required because there was no manifest necessity to support the declaration of the mistrial with respect to those charges. After careful consideration, this court concludes that because the defendant was not acquitted of any charges and defense counsel consented to the court declaration of a mistrial, double jeopardy is not implicated by retrial of the defendant. The motion therefore is denied. And it provides background. And I'm just skipping through it right here because it's more the background. More of the stuff we've already read about the jury. The supplemental affidavits, Juror D. And then the when the jury contacted ADA Lally and the prosecution. And it provides a discussion. Okay, acquittal of the defendant. And I'm just zooming through it because I don't want to rehash a lot of the stuff. Okay. All right, so it's like they're providing the motion to dismiss here. Which is the same motion Judge Bev denied. All right, and goes into the foreperson and the notes. All right. And I'm just not going to, again, I will leave the link in the description below for those who want to read through it themselves. But this addendum, this attachment is merely the defense's motion to dismiss, which I read previously. And Judge Canone's conclusion, her denial of the motion to dismiss. And they provide the Fifth Amendment, the Sixth Amendment, the GLC statutes, the Massachusetts Rule of Criminal Procedure, Rule 27B, Guide of Evidence, Massachusetts Guide for Evidence, and Certificate of Compliance pursuant to the Appellate Court Procedure. And it reads, I hereby certify that the above document complies with the rules of this court pertaining to the filing of briefs, including but not limited to Mass Rule 16A13 Addendum, Rule 16 references to the record, Rule 18 appendix to the briefs, Rule 20 form of briefs, appendices, and other papers, and Rule 21 redaction. This brief complies with the length and typeface limitations in Rule 20A2 and 20A4 because it is the proportional font Times New Roman, size 14, and contains 10,966 total words in the parts of the brief required by Rule 16A5, 11 as counted using the word count feature of Microsoft Word, dated September 24th, 2024, Martin G. Weinberg. All right, Certificate of Service, September 24th, 2024, Supreme Judicial Court, Clerk's Office, John Adams Courthouse, provides the address. Dear Sir, Madam, herewith is the brief and record of appendix of defendant appellant Karen Reed. Provides the case number, Commonwealth versus Karen Reed. I certify that I have made service via email of this brief to Caleb Schillinger, Norfolk District Attorney's Office. So Caleb is the new prosecutor in the Karen Reed case. No more ADA Lally. Maybe they got word that the internet doesn't like him. Okay, and it's signed Martin Weinberg, and that's the end. Page 77. So the defense was required to include the motion to dismiss and Judge Bev's denial of their motion to dismiss with this filing. So again, the original link to the PDF will be provided in the link in the description below. Thank you for bearing with me through this document, and I hope it was informative for you as it was for me. And prayers, people, prayers that the appellate court considers dismissing at least one thing, or at the very least, like I said in the beginning of this video, prayers that the appellate court at least allows the jury to come back, so that hopefully someone will do the right thing. Someone will do the right thing and acquit Karen Reed. Thank you for watching.